If anything, what this opinion is just a vindication of the basic separation of powers and the, I think, durable form that the American founders gave us.
Join the best in the movement. It's Conservative Conversations with ISI, educating for liberty since 1953.
Welcome back. You're listening to Conservative Conversations with Marlo, Slayback, and Tom Sarrouf.
And joining us today is Garrett Snedeker, who's the Deputy Director of the James Wilson Institute on Natural Rights and the American Founding, as well as the co-founder of their publication, Anchoring Truths, and he runs their podcast of the same name. He's a graduate of Amherst College and of the Antonin Scalia Law School at George Mason University. And Garrett's my old boss at JWI from back when I was an intern. And so he's the reason I got into podcasting initially. So it's very exciting to have him on to discuss all the old issues that we used to talk about in the office. And, coming full circle, so to speak. So it's a blessing to have you on, Garrett.
Well, I will say the real treat is actually for your listeners to the ISI podcast, because this is one of these instances where the pupil has far exceeded what the teacher has imparted onto him. And so all of you, who are regular listeners to the ISI podcast, please know, we just got Tom started in a very modest way, but boy, he has run with it. And this is just such a great podcast. So a must listen. And if you haven't smashed that subscribe button, please do it now.
Oh, you flatter me, Garrett. You flatter me. But yeah, we're talking about all of the cases that came down in the last few weeks here at the end of the SCOTUS term. But I think probably on a lot of people's mind, very relevant to the 2024 election and some of the legal issues. And I know you just wanted to touch on it very briefly, but Trump versus U.S., the immunity for official acts, but not non-official acts, and the sort of ramifications that has had for some of his federal indictments and potential convictions, and then even the New York case. So what's the upshot of and the broader implications of the ruling here?
Yeah, so this is the case that I think every lawyer in the country had to at least look at, right? The first time that a former president, was convicted in a court, and this on the immunity charges, this would have like direct bearing on those, at least follow-up proceedings. And I think, just for the benefit of our listeners on this episode, I think there's really a lot of, as Chief Justice Roberts said in his majority opinion, a lot of fear-mongering that's gone on with the majority opinion. This was Chief Justice Roberts' criticism of the dissent from Justice Sotomayor. I think what Americans who are not lawyers, should take away from the majority opinion is that this is a modest extension of older and far, more grounded in experience precedents. For example, Nixon versus Fitzgerald from the early 80s. This really extends it to the context of criminal charges. It's, I think, a perfectly sensible position, even if you are someone who is not an originalist. In many ways, this opinion is very practical, and it's trying to head off at the pass charges that one executive can make, against a previous executive. And so, if anything, what this opinion is just a vindication of the basic separation of powers and the, I think, durable form that the American founders gave us. But in a way, it's also somewhat of a calculated position that we, as a country, are far better off without executives and former executives at loggerheads with one another and using the courts as lawfare. And so I think the court was definitely looking ahead rather than just looking at this one case in its ruling.
Hey there, listener. I wanted to take a quick moment to thank you for listening to Conservative Conversations. This podcast is a production of the Intercollegiate Studies Institute, and our mission here at ISI is educating for liberty. If you'd like to join us in fulfilling our mission, consider helping us by rating and reviewing this podcast on Apple Podcasts, Spotify, wherever you listen, to help us reach more listeners like yourself. Now, back to the show.
For those of us who didn't follow this very closely, could you provide some of the context and background for why this case even exists? I'm sure this has been like a a media spectacle for, however long, but what's kind of the one-on-one 101 lesson on why this case even, materialized in this way?
Yeah, so the court really did not get to a ton of the concerns that it could have in this case, right? They were only ruling on whether or not Trump could essentially talk to his DOJ and whether or not that would have constituted an official act worthy of protection. And so the court said, indeed, this was something that was part of core presidential functions, and this is something where the president would have what they call presumptive immunity. It wasn't part of the absolute immunity, right? Like the pardon power, for example, outlined in the text of the Constitution under Article 2. But this was what the court called presumptive immunity, and it passed that threshold. There was, I will say, a very, I think, useful, particularly for law students to read, discussion of, for example, what actions the president and the vice president would have, interactions, I should say, the president and the vice president would have together, and what would fall under the presumptively protected actions, and which ones would be more of an open question. That's all fine and good. Those were not firmly or fully resolved. I think the court wanted to give guidance here, and really was looking forward to a time when these types of cases would not come before them. And so, just to answer your question, very, very high level though, Marlo, they were looking at the conduct between November, 7th, I forget, the day after the election in 2020, and then in the lead up to Biden's inauguration. Those were the key moments when they were looking closely at the conduct of former President Trump. But they really did not want to write an opinion which was so fact intensive to be not very helpful for guiding how either a future court, or remember there's something like a separation of powers aspect here, where the court is trying to communicate to the other branches, be it the Congress as well as the executive, what it will hope that the other branches will act in light of the reasoning of the court. Remember, the court only decides cases and controversies. The court does not provide advisory opinions, and that's very important when I think we talk about a couple of the other cases that the court decided this term. But it is very important that when the court issues a ruling, that there is an active case in a controversy, as opposed to offering just some speculative guidance. The court can certainly steer, especially in its way that as the court telegraphs which kinds of cases, for example, they would welcome and smile upon. But I think you could look at this, this as an example of the types of cases this court really doesn't want to see in the future.
Yeah, let's actually turn to some of that, because the Trump v. U.S., the presidential immunity thing is, I think, very live for the sort of electoral reasons that are upcoming, but more of the substantive constitutional jurisprudence cases that animate the work of the James Wilson Institute and legal conservatism. I think the big one is the Loper Bright versus Raimondo, the overturning Chevron case. So I'd love to dive into that. We've done the administrative state a few different times and with a few different people, but for maybe new listeners or people who need a refresher, if you could remind us all what the Chevron Doctrine is, and then move into why it was overturned and the sort of the reasoning behind overturning that precedent.
Sure. Yeah. So For your listeners' benefit, they should also know that I am a part-time staff attorney at New Civil Liberties Alliance, which was the public interest litigation shop that brought the companion case to Loper Bright. That was called Relentless versus Department of Commerce. Relentless is the name of the fishing boat company that, like the Loper Bright Enterprises, which owned a bunch of fishing boats, they were the harmed parties. That in 2020, there was this brand new change in a regulation, which was done by NOAA. And what happened all of a sudden was, where before 2020, there was a requirement that a monitor be on each fishing boat to oversee the catch on the boat, where before 2020 that cost had to be borne by the government. There was a change in the regulation which now said that cost had to be borne by the fishing companies. Now you might wonder, like, well, I don't know, maybe that's normal. Well, unfortunately, this change was not normal, and it was such a harm to these companies. Overnight, the highest paid person on each one of those boats was now the darn monitor for the government, as opposed to the captain or the crew, right? This was such a harmful change that immediately suits started cropping up. And so New Civil Liberties Alliance inherited a case that initially was brought by Cause of Action Institute and a lawyer named John Vecchione, one of my fantastic colleagues, who then shepherded the case through the lower courts. Now, why and how does a bunch of fishermen implicate this 40-year-old, dare I say, it was up until recently the most important precedent in administrative law? It was cited thousands of times, if not hundreds of thousands, if you include law review articles and briefs. Like, why was this the vehicle to challenge this old doctrine? Well, it had been a long time coming in the conservative legal movement, rethinking the Chevron Doctrine. Now, when Chevron came down in the 80s, it was heralded as not exactly the biggest deal, but it did mark a change. So what was the situation before the decision in 1984, Chevron versus Natural Resources Defense Council, and then what was the legal situation after? Well, before 1984, the DC Circuit in particular, but many lower courts, basically had a wide variety of multi-factor balancing tests for what would happen when a regulation was ambiguous and difficult to understand. Up until that point, you had lower court judges, in particular the DC Circuit, basically applying their own standards to how they were going to suss out ambiguity. Now, why was this a potential problem, and why was this something that Republicans who were either at that time like nouveau originalists or just skeptics of what the DC Circuit and lower courts were doing was a problem? Well, the DC Circuit had become a bastion of basically creating workplace, environmental regulations without the input of the executive branch, basically creating law without the political input of both the executive branch and the political branches. Now, 1984, the Chevron decision comes down. It's a unanimous decision written by Justice Stevens. Its intellectual architecture had not been built up yet, though. This was seen as a switch or a change, but the Chevron decision actually gained the kind of prominence that we now understood it to have had, mostly through the sheer force of intellectual argument that then Judge Antonin Scalia provided by his support of it. Then Judge Scalia becomes Justice Scalia, and Justice Scalia, he writes in this very famous 1989 Duke Law Review article, at that time, it was the strongest defense of Chevron as basically clearing up the multiplicity of views on what constituted ambiguity and putting in the hands of the executive branch, which, remember, at that point was the Reagan administration and then the Bush 41 administration, putting in the hands of those Republican administrations at least some political oversight and accountability. Now, doesn't that sound really nice and charming in retrospect? Before the rise of a what we would call like a univocal, or like some might say like the uniparty within the administrative state. The administrative state having kind of what we would consider today like the association of 90% Democrat donors and then 10% Republican donors, I think was probably more even back in the 80s, but you would certainly have like a skew. However, the real problem was that Chevron, after it came down, has number one the imprimatur of Scalia, who even in the late 80s was being seen as like sort of the intellectual godfather of originalism, and if you were a liberal, you could say like, well, even Justice Scalia thinks that this is a fine precedent. Plus, you had lower courts saying, oh, thank goodness. It was so difficult in those years before Chevron. We had to expend enormous judicial resources, and we were kind of, in a way, making it up as we got along. Chevron is such a neat and easy two-step formula. The formula was, step one, if you have ambiguity, defer to the interpretation of the ambiguity done by the agency. Now, that's step one. And if you can get past step one, you're home free. Why? Because step two was even easier. Step two was, as long as there's ambiguity and you put forth, and then it's kicked off to the administrative agency to resolve, as long as that ambiguity is given a reasonable interpretation, then you're done. Now, why was this something that the lower courts ran with and then it was kind of rubber stamped on it? Largely because that two-step process was something that was far easier to administer, and then on appeal, it was easier to check the record on. So you did not have nearly as many like fact-intensive checks as I think now, because we're kind of going back to the pre-Chevron world with the ruling in Loper, Bright, and Relentless. You're going to have that fact and law distinction become a lot more important, because with Chevron, it collapsed the fact and the law distinction, meaning judges are good on the law, juries are good on ascertaining facts. Chevron collapsed them. Now we're back in the world of juries are primarily for determining fact, and then judges are for determining the law. And these agencies, they're going to have to go to court. They're going to have to go to court and really work their butts off to justify why there may be ambiguity that they want to resolve in one way. There was, however, in the court's decision in Loper, Bright, and Relentless, what some might call a big hole. And the big hole was this, that they did not resolve the question of non-delegation. Now, why are the ISI listeners why are they interested in non-delegation? Well, non-delegation is this idea that as a legislature, you can't give away power that is inherently yours. The Loper Bright decision was not a decision that reflected the view of non-delegation, however. Only two justices, Thomas and Gorsuch, endorsed the non-delegation view. This Loper Bright decision leaves a big hole for if a future Congress decides to explicitly put in a statute that it will gladly allow an agency to clear up any ambiguities with their own interpretation. Then we're kind of, by legislative diktat, back in the world of Chevron. But the big difference is now, instead of a presumptive understanding of everything's in the world of Chevron, now it's only when the legislature makes it very, very, very clear that this is the exception. Now we're back in Chevron world as we were. So the Loper Bright and Relentless decisions definitely constituted the biggest decisions from like a 30,000 foot view of how much the law changed this term. However, if you're a public interest lawyer, I am part-time, you could probably make a pretty good argument for why this has been something that has been somewhat predictable for years, so it wasn't as much of a surprise. But there's also a few other decisions that the court made that may be from a practical perspective much more like useful in the toolkit of the um, lawyer that is like deeply skeptical of the consolidation of power within the administrative state, and we can talk about those. But definitely, like if you're looking at why the 2023 24 term was significant, you have to cite Loper Bright and the relentless decision, because the court could have become, the court could have issued a more modest ruling. This was a pretty strong ruling from Chief Justice Roberts. Again, not as strong as it could have been if you wanted him to touch non-delegation, but he didn't go that far, likely because I don't think he was going to be able to have at least a 5-vote majority for that.
What I have taken so far from the conversation after this case was determined was, and correct me if I'm wrong, but it's from people who are a little more sympathetic towards these federal agencies and their ability to function, it's almost seemed like they're saying, well, now these judges that are unaccountable to the people are now able to, exercise, or rather, they're the ones who are able to kind of show a little bit more. It's a severe blow to the people who, or the federal agencies who would otherwise kind of have very little friction to decide certain things, whereas now it's judges who are unaccountable to the people who are able to kind of have some sort of take on these matters. But how does that make sense when the administrative state and these federal agencies are also pretty unaccountable to people, as we've seen? I mean, when it comes to matters like, obviously we should have some concentration of extra expertise in some capacity in federal agencies, like on issues from pollution, whatever. But what's your read on the blowback of that case?
Well, the dissent from the 3 liberal justices kind of reflected the received wisdom of why the administrative state has sort of, in the words of the law professor Gary Lawson, has risen and then risen even more. The deference to experts reflected a desire, as much as anything, for Congress to not have to expend their resources on matters that, given their limited knowledge and the limited time that they could devote staff to ascertain answers to, it was viewed as very pragmatic. The problem with Chevron, the 40 years from Chevron to present, was that what you never really got was something like the kind of interest from the Congress that we have an institutional prerogative here that is being ill-served by Chevron. And so this is sort of fed into, I think, something which has come up multiple times on the ISI podcast, which is this just lack of Congress's interest in asserting its own will and prerogatives. And what the Chevron decision returns, again, with the exception on non-delegation, returns is a strong measure of political accountability, particularly on these questions where maybe you could sneak in through an ambiguous statute a pretty big regulation. Some of that had been cleared up in recent years. There was the West Virginia versus EPA decision in 2022, I think, on major questions where the court, because it didn't have the Chevron question resolved yet, the court was trying to say that once you get to like really, really, really costly questions, you can't have Congress totally punt. I think the deference to experts was a useful kind of cop-out. With this decision, though, in Loper Bright and Relentless, you now have the door wide open for Congress. And the hope is that Congress will now be in a far stronger position to be able to legislate substantively. And then when it truly feels out of its element, when it truly wants to delegate, then it will actively, in the legislative process, identify those areas of its own limits. Now, I will say that puts a lot of hope onto the Congress, which may be improperly placed. However, there there's probably a need of something like a culture change that this Chevron decision, if this Chevron decision doesn't do it, then you probably have even deeper problems.
Yeah, Garrett, just on the sort of major questions doctrine, because you have that, which I remember when I was an intern, we were talking about, like, this is sort of a way of, within the Chevron paradigm, kick some issues back to the Congress to say you have to deal with this. You can't just give the power to, the EPA or pick your agency. Is that still in effect in light of Loper, Bright, and Relentless? Is that something that sort of coexists with the new paradigm of we're going to move back to the courts sort of doing the fact law thing? Or do they mention it all? Like, so there are going to be some issues where the courts, it's not their prerogative or it's not their place. It's actually something that has to be kicked back to Congress.
Yeah, major questions is going to continue to be an area where you see lawyers litigating. I mean, it's after the Chevron precedent was overturned. You're just going to now see like public interest lawyers in particular, but even non-public interest lawyers who are just representing clients that have Administrative Procedure Act claims. They're going to hit all of these areas. I would say these precedents, if they don't echo one another, if they don't rhyme, they echo. I mean, this let's remember the three jurists that were chosen by President Trump. They were consciously chosen by folks in the legislative, on the Judiciary Committee, in league with folks in the White House counsel's office. They were chosen for their their own expertise, or more like their interest in administrative law, particularly Gorsuch and Kavanaugh. Amy Coney Barrett's much more like a federal courts nerd, and that reflects her interest in those standing decisions that also were quite prominent this term. But all three of them had very, very well thought out views on administrative law. It should not have come as a shocker that these would be the areas of law that the justices are very interested in taking cases and offering very well fleshed out opinions.
Well, great. Maybe let's turn then to the some of these standing questions on I think abortion, and then sort of free speech related issues and government censorship. Start with abortion. It was FDA versus the Alliance for Hippocratic Medicine, and the mifepristone, if I think I'm pronouncing that correctly. The Supreme Court allowed that to continue to be legal. Maybe you could fill into some of the relevant details of the case, but also, does this actually change anything in the court's jurisprudence on abortion and life issues, or is this more like a procedural defeat?
All your listeners should be given very much like a gold star if they've been reading these opinions that come out of the court on standing, because even the lawyers feel like it's a slog to get through them. Whenever a case gets decided on standing, it becomes a case that used to be all about the merits, meaning like the subject, the meat of why this was brought, to then, as you were saying, Tom, procedural questions for why this is even in court in the first place. And so both of the cases that you're alluding to, the Alliance for Hippocratic Medicine or mifepristone case on abortifacients, but then also the decision in Murthy versus Missouri on free speech and the social media companies being jawboned by the Biden administration. These were decided not on the substantive grounds of was anybody's constitutional rights, were they actually violated, but rather the question of should these litigants have even been able to get into court in the first place. So just big picture, why were these questions on standing so so important this term? Well, as you said, they were dealing with underlying cases of great importance for law and the culture. right? Like the availability of one of the most popular abortifacients, particularly in a post-Dobbs world, where fewer and fewer abortions are happening with children over the first beyond the first trimester, and more are happening through these pills in the mail or prescribed or over the counter, right? Like this is now the direction where especially in a post-Dobbs world where these abortions are going, and then in the Murthy versus Missouri context, right? Like we are now well aware that there is a digital public square. The First Amendment is not going to govern the guy in the middle of the square holding a sign. Like this is the First Amendment is going to cover that, but it's not going to have that as your kind of like flashpoint nearly as much as how Americans are interacting with one another on social media platforms. These are really, really, really important matters that affect millions, and the facts of each one of these cases, these were not like pulled out randomly, right? Like we had very much like clear parties, and they were bringing forth concerns that not only they shared, but also other Americans shared. So the ability to get into court, or the questions of standing that these cases were ultimately decided upon, were a way for the justices to avoid what were these central political controversies, like basically like these controversies that really like touched our politics. It was a way for the justices to try and firm up which types of cases got into court. And I think in both of these instances, the justices missed an opportunity to show that the court can have a modest role, even if it didn't have the most pronounced and prominent role. In the Mifepristone case, we had, in particular, a lower court judge, Matthew Kaczmarek, do some very intensive fact finding, and his opinion in the lower court was able to provide the kind of fleshed out contours by which we could understand what was the actual science going on in these opinions. Now, there have been Sturm and Drang after his opinion came down, with medical journals reviewing what were the facts, but and whether or not all of these studies can be replicated. As a side note, many cancer studies have trouble being replicated. So just to forward the the scientific analysis of these questions is in the public interest. But Judge Kaczmarek was certainly offering a ruling which was one that did recognize that at the very least there was a plausible case to be made here, and these abortifacients, mifepristone, presumptively they should be pulled off the market until we can actually understand. Like if you're going to trust these experts at the FDA, we should understand what the science actually does say before allowing these drugs to stay on the market. So the interesting thing about standing in the mifepristone case was that the lower courts, Judge Kaczmarek in the Northern District of Texas, and then the Fifth Circuit, I think it was Judge Elrod, they largely were also like allowing the case to proceed, but still pursuant to whether or not we actually did have the harms to be sussed out here, right? Like the tough call that had to be made, even those lower court judges knew, was on the standing question. So what was so difficult, and what eventually amounted to the 9-0 Supreme Court majority against standing in the mifepristone case? Well, and this was Justice Kavanaugh's point. Justice Kavanaugh found that the problem was that there was a too tenuous connection between the doctors and then the pro-life medical associations argument that they would be uniquely harmed by the FDA's mifepristone changes, right? So basically there was there were a series of instances in which the FDA relaxed its standards, right? And so by relaxing its standards over the last 20 years on mifepristone, these doctors and pro-life groups thought that you were actually going to be harming, the women who took these drugs, but also, in a post-Dobbs world, I know they didn't make this case, but like others did make the case that indeed we have another preborn person here that we're dealing with. But Justice Kavanaugh found that merely objecting to abortion or the FDA's policies, even out of sincere concern, that was not enough to bring the case into federal court. And he basically found that there was a missing link in causation, that the doctors and the pro-life groups could not connect in their suit. So, fine, Justice Kavanaugh was able to get 8 other justices to agree with him in this case. What does that mean? Doesn't mean anything about abortion. It doesn't mean anything about the actual underlying science of these abortifacients like mifepristone. All it said was that we, the court, we don't want to have litigants in our system with these kinds of more tenuous grounds. Fifth Circuit was okay with it. The district court was okay with it. Could you imagine another litigant, maybe in a post-Dobbs world, with a cause of action saying that like a guardian ad litem to a preborn person was harmed by somebody who took mifepristone, and the preborn person was born with a birth defect or something, despite taking mifepristone? Maybe. Or maybe you have another litigant in a post-Dobbs world where you bring forth a case and the child's mother the child's father wants to have a child, but the mother takes mifepristone, and then you have birth defects, right? Like, you can imagine other scenarios. This opinion did not say anything about the underlying science or the merits. All it touched on was if you're a pro-life group or if you're a doctor that's concerned. That wasn't enough.
So I think we have enough time. I definitely want to get to Murthy versus Missouri. So that's interesting because it's actually a speech case.
Yeah.
So could you walk us through what happened here?
Yeah, so Murthy, I didn't work on this with NCLA, but Murthy, just like the Relentless case, that was an NCLA case. This really was like the term for NCLA, but unfortunately, whereas we were victorious in the Relentless case, we were not victorious in the Murthy case. But at least the court did not touch the merits. They ruled in Murthy versus Missouri on standing grounds, and so this one for the justices was a closer call than in the mifepristone case. Why was this a closer call on standing? Well, it's because I think the litigants themselves that were bringing these suits were the very parties that were harmed. And in so doing, the case became a lot more difficult to command a unanimous court. So what was going on in Murthy versus Missouri? Well, as we all remember, in 2021, all the COVID vaccines get rolled out, and very quickly there emerges a public health consensus, right? That these vaccines are safe and everybody should feel confident in taking them. However, then, as we all knew, this kind of gigantic push, coming from federal, state, and local government, gained skeptics. And some of those skeptics were actually experts in their own right. For example, Aaron Kheriaty, a professor at, I think, Cal Irvine, or he's basically a university at a public employee at a university in California. He comes out as one of the most prominent skeptics. But then you had regular old Americans who were voicing their skepticism. The question is, though, where they were voicing their skepticism, and then what would happen after they voiced their skepticism. So, in the case of Aaron Kheriaty, right, he had a big Twitter following. He had big followings on other social media accounts. You had other Americans, right, who were participating in Facebook groups. You had other Americans who were forming in-person meetings, but they were using the platforms to arrange for those meetings. All of these different exercises of their right to free speech and be able to share their own experiences with COVID vaccines and boosters, they were behind the scenes being suppressed. How did we even know this? Well, in the discovery in the lower courts, the Biden administration had to share the communications that its administration was having with social media company employees. And so during discovery, what came out was that you had efforts by the Biden administration to persuade these social media companies to shadow ban or to suppress the reach, right? We hear often like free speech versus freedom of reach. Right? You can have free speech, but you can't have all the reach you want. Well, that's what was going on here, or at least that was the justification that the Biden administration was saying. All we were doing was using our own governmental free speech, right? We were saying we should be able to have back channel conversations with social media platforms, just like we would have if we had an interest in preventing terrorism, or just like we would have if we had an interest in ensuring that we as the government were not like misunderstood, and like we would take all efforts that we possibly could to clarify our position. Now, what did all this amount to? According to District Court Judge Terry Doty, though, this amounted to not just persuasion, this amounted to coercion. And that's why the district court found that this was not just something that the district court should view disfavorably, but rather the district court viewed this jawboning, or using the using the executive branch's bully pulpit as being one of the worst violations and one of the most egregious violations of free speech. And so that's why you actually had red state attorneys general join in this case, because they saw that they could provide their resources to the public interest litigation outfits like NCLA, because they saw that this was much bigger than just a doctor here, or let's say a husband and wife that are very, very skeptical of their kids getting vaccinated as a requirement to be able to go to public schools, stuff like that. Like, this became much bigger than like individual unique flashpoints. But it was very, very, very important on the standing question that you did have parties that were like directly being unbeknownst to them until the discovery came out, censored or having like their reach diminished. So Fifth Circuit largely, as opposed to even in the Myth of Prestone case where they mostly agreed, but not as much as like the Fifth Circuit, in Murthy versus Missouri, like they really endorsed the lower court's ruling, and that's how that ends up at SCOTUS. But the problem was, at SCOTUS, what you had was a really, really tough time at understanding why this was something that was likely to occur in the future, or whether this was one-off. And in general, when it comes to standing, the courts, and in particular the Supreme Court in this instance, does not like when it's, in their view, it's something that doesn't rise to the level of happening again. So that's why Justice Barrett, in writing for the majority, said, and I wrote this down before we went on the air, so I didn't misquote her. She said that there was not a substantial risk that in the near future at least one platform will restrict the speech of at least one plaintiff in response to the actions of at least one government defendant. So they wanted to be clear that we could identify an instance where this one person would be harmed as a direct cause of this, like, shadow banning or censorship or these coercion efforts. Like, the replicability was the problem, and in Justice Barrett's view. Now, there was a really strong dissent from Justice Alito, and Justice Alito said, like, you don't need to have to tell us that there's a replicability problem. All we saw was the most like pervasive effort by the federal government to prevent Americans from exercising core like free speech, and this was something that like we cannot presumptively kick out on standing grounds. Like, we want to touch the merits for darn sake. Like, standing is not, a sufficient grounds to kick this case. Like, we think there is still, as the standing formula goes, you need to have a likelihood of suffering an injury or the injury suffered itself. You need to have causation. The injury has to be redressed by the judge, and it needs to be concrete and particularized. Like, you've met all those. Like, we think, or at least the dissent thought, like, you've shown that and then some. But again, it was kicked on standing. They did not touch the First Amendment question. But that should be, I think, like, let's take like a big step back and like see why these two cases together constituted something memorable about this term. Well, I think the justices really don't want to touch the substantive questions unless they absolutely have to. But they will go to egregious procedural violations. And you might be able to argue that that's why a court like the Supreme Court will go far in administrative law context, like Chevron. A couple of cases we didn't talk about yet: SEC versus Jarkazy on the deprivation of a jury trial for folks who are under an SEC investigation, as opposed to just being like dealt with by a special administrative law judge. That was a very big decision. But another one that was huge, again, from like a practical public interest perspective, this corner post decision, which Americans like everywhere, I think if you just gave them the basic like facts of the case and then you ask them what's basic justice, they'd all come up with the right answer. It's amazing it took the court as long as it did to remedy this problem. So in corner post, you had this little truck stop in somewhere in the Midwest, I forget. This wasn't one of our cases at NCLA, with apologies. The great team of lawyers at Consovoy McCarthy won this case. But Corner Post dealt with this small business that didn't want to be at the mercy of these regulations that dealt with credit card interchange fees that were in existence even before Corner Post even started up as a business. And so they were questioning the constitutionality of it. But Corner Post couldn't do so because the circuit that it was located in, the circuit court that it was located in, had a precedent that said, no, you can't challenge this unless you challenge it X number of years from when the regulation is approved. Well, Corner Post didn't even exist. How could it have sued? So there was a split between some circuits that said, no, you can, any party that's harmed by a case can sue within Y number of years, just so long as you bring your suit in a timely manner. But it doesn't matter when the regulation was, adopted. Corner Post thankfully resolved that split among the circuits, and and again, from a procedural standpoint, said that we are making uniform that the statute of limitations only begins when the business is affected by the regulation. Again, the court issued a sweeping ruling in Corner Post. These are big decisions. These are practical, changes that the court is more than happy, to overturn, precedent or resolve circuit splits on. But they're not big substantive. They're not big substantive resolutions. So this is just something that I think, as right of center, listeners of yours, sort of digest these court opinions. And then they might hear from their liberal friends like, oh my God, what a rogue Supreme Court. They'd be wise to tell their friends on the left, like, a lot of these decisions are very much procedural in nature, and this court is cautious as heck, even to the point of some of us who would like them to be issuing more like sweeping substantive rulings. We wish they were doing more, but for one reason or another, they seem to be sticking with more broad sweeping rulings on procedural heavy cases rather than ones that really touch on the substance of the law.
Well, Garrett, there's many other cases I think we could have talked about and things you alluded to. Unfortunately, we're out of time, so we'll have to have you back on another point and talk about some more cases and other live issues happening at the court and issues of jurisprudence and originalism and the work that you guys are doing at the James Wilson Institute. But if people want to follow the work of the James Wilson Institute, the stuff that you in particular are doing, where should they look? What do you recommend?
Well, I think the best place to look for our work at JWI is on our homepage, jameswilsoninstitute.org, and to sign up for our mailing list, JWINST for short.org. As lovers of a more thick moral jurisprudence, I think what we would like to see, just as like a restoration in this country, is an appreciation for how law and morality are bound up together, and that it falls to judges, even in a modest way, to have to acknowledge that there are some unavoidable questions that need to be answered in our jurisprudence. You can also follow us on Twitter at James Wilson Inst, and probably the best place to look for my work at NCLA would be at the NCLA homepage. That's nclalegal.org. NCLA is obviously very, very much delighted that this recent term had so many wins, but the future hopefully has even bigger and brighter things in store. So I'm just happy to be on this fantastic program. I'm a regular listener myself, and so this has been a real treat. Thank you, Tom. Thank you, Marlo.
Thank you, Garrett. Thanks again.
Yeah.
Thank you for listening to Conservative Conversations with ISI. If you've enjoyed this episode, be sure to check out our website at isi.org/resources to see all that we offer our members, including the Intercollegiate Review, select modern age articles, debates, lectures, and of course, this podcast. Thanks again for listening. Don't forget to rate and review, and we will see you next time on Conservative Conversations with ISI.